In July 2012, deputies with the Los Angeles County Sheriff's Office conducted a surveillance on a state parolee they thought was involved in criminal activity. Tak Tran, the parolee, had been overheard in monitored phone calls discussing illegal activity. Deputies went to the house they believed Tran lived at and, after watching for a while, snuck up to the home. They believed they would be allowed to conduct a parole search of the home. But it turned out the home belonged to Chong, Tran's nephew, and Tran did not live there. This week, we'll talk about the combined cases Chong versus the United States and Tak Tran versus the United States, a 2024 decision involving the Fourth Amendment right against unreasonable search and seizure. I'm Steve Serbalik, and I'm a panel attorney with ASCOPS in Arizona. The deputies stood about a foot from the open garage door they had snuck up on before they were spotted. Tran was surprised and tossed a baggie of methamphetamine on the table in front of him. Tran was detained and the baggie seized. After a protective sweep, the deputies obtained a search warrant for the house. Large amounts of cash, ecstasy, methamphetamine, cocaine, and marijuana, 3 guns, ammunition, and digital scales were discovered. Tran and Chong were later charged with federal drug and gun offenses. After failed attempts to suppress evidence, both Tran and Chong were convicted. Tran and Chong continued to appeal, and in one argument it was decided that deputies had failed to surveil Chong's home long enough to even establish that Tran lived there. However, the district court upheld the conviction because Tran had disposed of the drugs in plain view, and that meant the search of the garage was justified under exigent circumstances. Tran and Chong finally raised their appeals to the Ninth Circuit, but instead of appealing on grounds of a Fourth Amendment violation, they argued they had received ineffective assistance when their attorneys didn't assert that deputies had trespassed onto the curtilage of Chong's home. The Ninth Circuit sent it back to the district court with one simple question: where was the deputy standing when he saw the drugs? This image was used to show where the deputy was when he spotted the drugs, and the path taken to sneak up to the house. So, on returning to the Ninth Circuit, they had their answer, about 1 foot away. The Ninth Circuit first denied Tran's appeal. Since it wasn't his house, he didn't have standing in the argument. It's hard to argue ineffective counsel on the basis of trespassing when it's not Tran's property to trespass on. So that just left Chong. The court found that, based on the failure to establish Tran's residency at the home and the clearly investigatory reason behind the approach to the home, that deputies had absolutely trespassed onto the curtilage in violation of the Fourth Amendment. And they also found that the violation was so clear that no reasonable attorney should have missed it. So Chong's attorney provided ineffective assistance of counsel by not moving to suppress on that basis. The takeaway is this: these types of Fourth Amendment violations are so well known by now that attorneys are considered ineffective for not catching them. So don't find yourself trying to exploit loopholes to the Fourth Amendment. When in doubt, get a warrant. If you can't get exigency without further investigation, like walking up to the house, then you don't have exigency. If you have any questions or comments related to vehicle inventories, please leave them down below. Don't forget to like, follow, and turn on notifications. It really helps the channel grow. Be on the lookout for new videos. They come out every Sunday at 5:30 p.m. Arizona time. I'm Steve Serbalik. Thanks for watching and stay safe out there.